Thanks everyone for joining us today for our webinar on implementing the Uninterrupted Scholars Act in the States. My name is Dave Hanyak, and before we get started, I'm just going to run through a few technical details about the webinar. If you haven't used GoToWebinar before, welcome. In just a few minutes, our presenter, Jessica Fireman, will be sharing her screen with you, and it will appear in the window that's currently on your screen. All attendees' lines will be muted throughout the webinar to minimize background noise. And if you'd like to ask a question during the webinar, you can type it in the question area on the long box on your screen, usually on the right side. Please note, however, that we will not be answering questions during today's webinar. Instead, we'll be logging all of your questions and responding to those in our next webinar in this series. So thank you again for joining us today, and I will turn it over to Jessica, supervising attorney here at the Juvenile Law Center, who will introduce the rest of the panelists.
Thanks so much, Dave. And also, just an additional technical note, if you're having any issues with the webinar technology, please feel free to chat that in so that we can help you out. Welcome everyone to the webinar on state implementation of the Uninterrupted Scholars Act. Many of you joined us for our first webinar in this series. This is a series of 3. The first one provided an introduction to the Uninterrupted Scholars Act. And in this webinar, we'll be hearing from some really inspiring agency leaders from both Pennsylvania and Florida about their implementation efforts to date. So let me just take a brief moment to introduce myself. As Dave mentioned, I'm Jessica Fireman. I'm a supervising attorney with Juvenile Law Center. We are a national public interest law firm based in Philadelphia with a focus on advancing and protecting the rights of older youth in the child welfare and juvenile justice systems through policy advocacy, litigation, and public education. Juvenile Law Center is also proud and happy to be a member of a collaboration called the Legal Center for Foster Care and Education. Many folks on the phone have worked with us over time. We're a collaboration of the American Bar Association Center on Children of Law, Casey Family Programs, Annie E. Casey Foundation, Juvenile Law Center, and Education Law Center of Pennsylvania. We just want to let you know that we are here to be a resource to you on all issues affecting the education of youth in the Child Welfare Center. We encourage you to rely on our website, and I'll give you a little bit of a guided tour of it later, to use our listserv, to use our publications, and to reach out to us with questions. And as you'll see, our information about how to get on the website is right here. We are really lucky to be joined by fantastic panelists today. In the interest of time, I will keep the introductions short, and I'll focus on their current work, but in reading over their bios, of course, I noticed that they are really impressive folks with long histories of working to advance the well-being of kids and of the most vulnerable kids, and they are have many awards and accolades for their leadership. So we are joined by David Volkman, the Acting Deputy Secretary for the Office of Elementary and Secondary Education here in Pennsylvania in the Department of Education. In this position, Mr. Volkman directs statewide programs and oversees all Pennsylvania K-12 public and private schools, serving over 1.8 million students. We're also joined by Mary Cagle, who has served as the statewide director of Children's Legal Services for the Florida Department of Children and Family Services since 2007. Ms. Cagle has been recognized for her leadership in transforming Children's Legal Services into a statewide law firm with a focus on recruiting and training talented lawyers to be advocates for children in the child welfare system. We're also joined by Cindy Horshaw, the Acting Bureau Director of the Bureau of Policy and Programs and Operations in the Pennsylvania Department of Public Welfare. Cindy has responsibility for policy and regulatory issues related to child protective services, kinship care, foster care, and adoption. And as an advocate in Pennsylvania, I count myself lucky to have her as a colleague. We're joined as well by Gria Davison, who's been the state consultant for school social work services for the Florida Department of Education for over 19 years, where she analyzes legislative proposals, assists in the implementation of education-related rules and laws, and provides technical assistance and trainings in the state and nationally. And we're, last but not least, I'm happy to have Mickey Presley joining us. She's the Assistant General Counsel of the Florida Department of Education, who, among other things, has great expertise in FERPA. Ms. Presley received her JD from Florida State University's College of Law in 1999 and a bachelor's in 1993 from the University of West Florida. So thank you, first of all, to all of our panelists for joining us today. On our agenda for today is pretty straightforward. We have a really exciting opportunity with the passage of the Uninterrupted Scholars Act for states to build on their efforts to share information between child welfare and education agencies and to improve outcomes for youth in care. So we want to explore a little bit more about how states are doing that. We will start with a few short minutes on background discussing why the law is so important and what the law provides. For folks who are on the first webinar, this will be a review, but we'll try to keep it short and sweet. And then we'll turn to the panelists to hear, in states that have already made really great strides in implementation of the Act, what they've been able to do. In both Florida and Pennsylvania, the state child welfare and education agencies have worked together and issued joint letters to the field on how to implement the Act. So our panelists will talk about why they felt the guidance was needed, how they developed the collaboration, and what the guidance provides. And finally, I will guide you through some tools that the Legal Center for Foster Care and Education has developed to assist you in implementation efforts in your jurisdiction. As I mentioned earlier, throughout the presentation, please feel free to use the question box to chat in any questions that you have. If there's a little bit of time toward the end, we will try to take a few questions, but more likely we'll gather the information and use it as we're developing resources that we will then circulate back out to the field and try to address them as well on the next webinar. So for folks on this call, this isn't news, but there's just an incredible impact that education information can have on education outcomes for children in the child welfare system. When the child welfare agency has that information, workers within the agency can meet their legal responsibilities regarding school stability. They can help enroll youth and transfer credits. They can help identify needed services. And the child welfare and education systems can collaborate well to address the needs of youth in care. Information shared between the two systems can obviously also help at the system level. It can help the child welfare agency to identify systemic problems, to develop targeted policies, to collaborate effectively, and to track progress over time. Around the country, child welfare and education agencies have been working together and have at times struggled to figure out how to share the information carefully and within the bounds of law. The Family Education Rights and Privacy Act, designed to protect the privacy of children in the education system, has sometimes posed obstacles that have slowed the progress of information sharing. The new law, the Uninterrupted Scholars Act, passed in January, creates some really great new opportunities to overcome those obstacles. So very briefly, what FERPA provides is a federal law designed to protect the privacy of students' education records. It generally prohibits schools from disclosing personally identifiable information from a student's education record without the consent of a parent or eligible student. And as folks know, there are a number of exceptions to the rule. The Uninterrupted Scholars Act went into effect in January of this year, and it creates one of those exceptions to the requirement of consent. Information under the Act can be released, and by information I mean education records of a student, can be released without consent to an agency caseworker or other representative of a state or local or child welfare agency or tribal organization who has the right to access a student's case plan. When the agency is legally responsible for the care and protection of the student, and providing that the information won't be disclosed except to an individual or entity engaged in addressing the student's education needs. Obviously, the key question for this call and for states working on implementation is defining all of these terms. Which representative has right to access the case plan? For which children is the agency legally responsible? To whom can the information be disclosed? So we're going to focus the rest of the call on trying to provide some resources to help states answer these questions. I just want to alert folks also to the fact that there's federal guidance that's been issued, and that this is one short phrase I'll show you on the Legal Center website where to find the guidance if you want to look at the full piece, but it's worth noting that the federal guidance underscores the importance of interagency collaboration and of information sharing between child welfare and education. So with that, as a brief background and introduction, let's turn to our panelists. And what we're going to do is have a series of questions with short answers and go back and forth between panelists. So let me start with Mary Cagle and ask you this question. Why is the Act so important, and why did the child welfare agencies see a need for guidance on implementation?
Okay, thank you. Thank you, Jessica. I appreciate that. The bottom line, honestly, for us was FERPA seemed to be a barrier to getting done what we wanted to get done, both from the school side and from the child welfare side, to improve the outcomes for the kids in terms of their education. So the barriers existed, and the Act was so important, and I go all the way back to when the congressional group was touring the country. I mean, we went there and we said, please, if you want to do something, remove the barriers for information sharing between the systems, because it's a barrier to us helping kids. And so that was really the importance of the Act for us. And the other thing it did for us was, in removing some of those information sharing barriers, it allowed for our relationship between the Department of Children and Families and the Department of Education to just, we always had a relationship, but sometimes we together banged our heads against the wall because we couldn't get done what we wanted to. It removed those barriers and allowed us to just connect at the hip to solve problems. So that was a huge thing for us. And to answer the second part of the question on the need for guidance, I mean, we wanted to define some of the terms. We wanted to put out there that we were partners in this work and both, focused on the end game. And we also were in the process of doing a lot of information sharing and planning on how we were going to share information electronically between the school district systems and the child welfare systems. And we wanted to put out there in the letter kind of to a large audience where we were going with that project.
Great, thanks so much, Mary. It looks like we were due to be joined by Cindy Horshaw. I don't see her name showing up on my screen. So Cindy, if you are on the line, please log in through the webinar service, and you should show up as a panelist or chat into me to let me know that you're on the line. But assuming that Cindy has not yet been able to join us, I'd like to ask the same question essentially of the education agency representatives on the line, which is, what does this Act mean to you, and why did you see a need for guidance to the field? So let me open it up with David Volkman from the Pennsylvania Department of Education.
Good afternoon. Can everyone hear me okay?
We can hear you over there, and folks on the line
Great.
won't be able to respond, so we're hoping that they can. Thanks, David.
Good, only because we've had some issues with our new telephone system. But anyway, really our work on this goes back several years, about 2.5 years. We weren't really focused, quite honestly, on the Uninterrupted Scholars Act. We felt the real need to pull a team together from welfare, education, and the courts. And we actually pulled in groups from the Office of Children and Families in the courts, court administrators, as well as folks from our Special Ed Bureau here, policy office and legal office in both the Department of Education and in DPW. The reason we did that is because there were so many issues around what we would be calling, I suppose, educational stability, for foster children. And so as a result of that, we put together a plan, a work plan, and the most important part of that was objective number 1, and that was to increase the collaboration between our various agencies. So we brought all the stakeholders to the table. We set up regular monthly meetings, and so we actually began pulling together FAQs, which I can certainly share with folks, on the education of children in foster care or awaiting foster care placement. And so as a result of that, when the Uninterrupted Scholars Act came along, we felt it was extremely important to let the field know that. Pennsylvania, as you may or may not know, and of course you do, Jessica, we have 500 LEAs in the state, and we are a local control state. So obviously when we work with our school districts, we try to get the word out as quickly as we possibly can to let them know the importance of pieces of legislation that have been passed. In the letter itself that went out, the joint letter from Dr. Dumaresque in our department and Beverly Makareff, the Deputy Secretary for the Office of Children, Youth, and Families in DPW, we did a lot of work back and forth, a lot of conversation between the leadership, and I think it's always important to have agency leadership involved. We need to stress with them how important it really is that not only do we collaborate, but we send a singular message out to the field. And so obviously when you get a chance to look at the letter that was produced here, we did a very, very brief overview of highlighting the act itself. And we wanted to get right to that piece on the exception under FERPA that deals with the agency caseworker, because we had real experiences of people being in touch with us, you know, the difficulty they had in accessing records and making decisions for children. So the next part then, obviously, after we went through the exception and talking about agency caseworkers having authorization to access records, we delineated who they were, what they could obtain. We also talked about the credentials that they had to produce, indicating that they had a proof of a relationship with the child. We also re-referenced FERPA, and we also talked about the involvement of agency leadership, this obligation we have to continue to work collaboratively, and also to let folks know that caveat in there that we're not usurping a parent's rights, certainly. It's allowing the child welfare agencies to obtain the student's educational records in a more timely and efficient manner, because, you know, sometimes we were hearing horror stories about the number of days that it would take for those records to be shared. And again, indicating there are no rights certainly being taken from the parents. And then we gave them a series of subsequent steps, certainly that in terms of what the parent can do, and also if there were issues with abuse and other matters, and the neglect of a dependency matter or something like that, again, how that would play together. Obviously, you can't go on in a rambling dissertation if you're talking to 500 LEAs, because they'll very often go to the pupil services directors in the various school districts and charter schools. And this way, we thought we would make it, you know, short and simple. And then we followed up in March with a whole, the FAQs on the education of children in foster care or awaiting foster care placement. So we thought that it was kind of a good idea to let the field know what the Act said, and at the same time promoting stability for children in foster care or those awaiting foster care placement. So my recommendation is would be that if you're getting involved in this kind of work, to make sure you do collaborate with the other agencies that are involved, in our case DPW and the courts, and the fact that you have clear goals established, you have action steps outlined, make sure you have the point people that are responsible involved, and then you have to really talk about measurable outcomes. We continue to follow up with this through our Office of School Services here at the department. We've actually targeted folks here to be responsive for us in case there are issues that would come from the Uninterrupted Scholars Act. And to help me today, I actually went over and talked with a couple of them to find out, you know, where we were. Have we had a lot of negativity? And interestingly enough, we haven't heard anything from the field. We had a couple of questions early on when this went out, shortly after the passage of the Act, but we have gotten very little negative feedback, nor have we heard, at least from the education perspective, of districts that are not cooperating with those who come requesting information, who are caseworkers. I'm not saying they have to run in there and wave the FAQ or the actual letter, the joint letter, in front of the folks in the LEAs, but we thought maybe we'd have a little bit of pushback because it was a slight change in practice, but to date, it's gone very, very well. So probably the bottom line for us has been the ability to work with very, very good people and other agencies to get our leadership involved, to get them to be collaborative, and the fact that we actually had both of our deputy secretaries sit down and interact with each other and frame out what they wanted to do. And they were very much involved in the writing of this, and their chiefs of staffs were very much involved in the writing of this.
Great. Thank you so much, David. That was a really helpful overview, and I think you raised an important point about local control, and not, which is not a Pennsylvania issue only. Around the country, there are so many school districts, and having this, the kind of guidance that Florida and Pennsylvania have put out really helps to clarify what's required around the state. So let me turn it over to Gria Davison. If you could also speak to this initial question of why the Act was important to the education agency, and why you saw a need for guidance to the field.
Hi, this is actually Mickey Presley from Florida. And in addressing this question, I would say that prior to this enactment, some of the schools and the school districts in our state would previously deny access to students' records to our Department of Children and Families because they were wrestling with issues about whether the agency was in the place of a parent in a particular situation. And in some instances, some of the districts were requiring specifically that the court order expressly state that the agency had a right to the educational records of the student. And there really was no consistency across districts. So one of the needs was for consistency, and was to get away from having to prove up separately in some kind of ambiguous way that the agency stood in the place of a parent.
This is Gria. Thanks, Mickey. I'll add to what Mickey has already indicated, and that is, in Florida, we experienced a variety of responses from our individual 67 school districts, and one was what Mickey just indicated, as well as dealing with the Florida state definition of parent at the time, which didn't indicate a state agency. And then we had issues of releasing records, and some districts did very well with that, and others did struggle specifically with that. The result was that caseworkers and other DCF agents were having difficulty getting real-time data to deal with students and their custody issues, and they were sort of burdened with how to make that happen. So we did have a variety of responses. So the consistency was obviously something that was needed.
So we know that kids in foster care are at risk educationally. They struggle for stability. They may have trouble in progressing educationally or in graduating. So really we need to eliminate whatever bureaucratic red tape we can and make the transitions seamless. And we think that the Uninterrupted Scholars Act works on two levels to eliminate the red tape. First, it'll assist the individual caseworker by allowing them to get individual student records without an additional order and without placing notice to the parent, just by presenting an order showing that the student is in the custody of the agency. And secondly, and maybe most importantly, it paves the way for an automated exchange of educational data in real time between a school district and the child welfare agency. And that data will be readily accessible. It'll be timely data, and it will allow report-driven information for caseworkers and for supervisors in the child welfare agency. For example, attendance data that they can look up periodically, so that a caseworker doesn't spend their time going down and chasing the information down. They spend their time following up on the information if a student is showing that they're not attending. And so we see that as a tremendous need and a tremendous benefit flowing from the Uninterrupted Scholarship Act.
Additionally, this is Bree again. Additionally, I think it's important to note that prior to the Uninterrupted Scholars Act, school districts, were for the large part doing a very good job, I think, with trying to work through the struggles, and did that in terms of complying with the then existing FERPA requirements, and that is releasing individual student records, but based on parental consent or dependency court order. That in and of itself, was a way of releasing and for the DCF agency to obtain those records, but it was cumbersome, and in many times did not respond to the urgency that DCF caseworkers and others needed in order to obtain that information in a timely manner, which was critical and still remains critical. So working through the existing FERPA requirements in order to do that did present itself a problem. So this is a win-win for all, because the end result is that everyone is able to be focused on what's best for the student and to get those records into the proper hands so that we can problem solve and serve kids better.
Great, thanks so much. That's really helpful information. I want to just jump in with a couple of points. There was a question chatted in about whether there are slides that go along with the panel's presentations, and the answer is no. There's nothing wrong with your computer. We are just going to have this as a more informal conversation portion of the webinar. However, what I will do after this is show you where on the Legal Center website you can find the copies of the Florida and the Pennsylvania guidance or joint letters that were issued that are being described here, so you can look them over in further detail. I also saw a chat-in question about a problem with the sound. It's sounding clear from my end, but please do chat in other folks if folks are having problems with the way the sound is coming through in the webinar. A couple of folks have touched on this already, that the joint guidance on the FERPA issue came out of a strong collaboration between child welfare and education, and I'd like to ask our panelists to talk about that just a little bit more. So Mary Cagle, if I could turn it over to you with that question.
Sure. Well, I just sent an informal email chat privately, but I'll share it with you. After listening to Mickey and Gria, I got to tell you, I love my Florida DOE partners. I mean, and this change in the law just released us to be partners and work together. So it's just really been phenomenal. We had in place, in terms of developing collaboration, with the help of our Florida Department of Education, they put in place a foster care liaison system. So the schools all have somebody who is a foster care liaison and works with the child welfare folks. I mean, in the Department of Children and Family side, I have education lawyers assigned in every circuit. So we had a lot of different sort of informal and formal ways to connect to each other. We participated in all of the Washington, D.C. convened, court, education, and child welfare collaborations. Those were very, very helpful convenings, not only to put us on point for the issues, but also to really, define who the partners are and define the work. So that was all very, very helpful. So we also do a quarterly meeting where the Department of Education and the Department of Children and Families hold or convene a meeting for everybody across the state of Florida, and we often get 200 people calling in or more, but it's all the child welfare folks, the education folks, Early Learning Coalition, lots of, we try to get sometimes the ABA folks, the Casey folks, but we share best practices and, we share information together about what we're doing. So that is all sort of in place. So a lot of that helped us. We had done so much talking about, even though we shared the end game, how could we work together to get there? And I got to tell you, FERPA was a barrier. So when this happened, we just circled the wagons, became complete partners, designed the letter together. It went out, and now we're doing joint trainings. The other day, they invited me to be on the phone with all the foster care liaisons in the school system. Much of what we're doing right now is sharing with the field what our plans are for Florida in terms of the electronic data sharing, which I'll explain a little bit later if anybody's interested. But in terms of the collaboration and how we put it together so that we could get the joint letter out, I think all the groundwork was in place. I got to say, FERPA was a barrier, and once this amendment passed, it came together beautifully. And really, huge thanks to Gria and Nikki for making that happen.
Great, thank you, Mary. Let me turn to the next question, which David touched on briefly, but what are the key points in the joint letters that you did issue to the field? And on the Florida side, I'll let you all decide who wants to speak to that issue.
I'm happy to just briefly respond, and then Nikki and Gria can respond. What we wanted to do was put out the positive news, and we see it as positive. And the slide you had up there from the Fed basically saying we passed this so you guys can share information. And that's huge, and we wanted to put that out. So in our letter, we recognized the extremely positive change to remove barriers. We wanted to define the legally responsible and let them know how we in Florida were interpreting that. We had no problem really coming to the position we had. We also put our letter out really in large part also to share with the field where we wanted to go in terms of electronic daily or every other day or weekly upload of the district schools in educational information on specific children into our SACWIS system for case managers to access. So we wanted to put that out in our letter. And I think we wanted to, just say to everybody, we stand together, we share the common goal of improving outcomes for these kids, and we're partners in this work. So those were the key points in our letter from my perspective.
Great, thanks so much, Mary. And I will say that was one of the things that I think is very strong in the Florida letter is how it highlights the intersection between the technology and real-time sharing and the general information sharing rules under FERPA. So folks should definitely have a look at that letter. Pennsylvania's letter spoke more to exactly what kind of proof does the education system need to see to know that they can release the information. Which people can they release them to? And so we'll talk a little bit more about that in a little while. I do want to ask one more question, which is how is implementation going? And for folks who have started, I know David spoke a little bit to this and said on the school district side in Pennsylvania, from our 500 school districts so far, he hasn't had any problems or concerns raised by the school district. But are there lessons learned or suggestions that you have for others working to implement the Uninterrupted Scholars Act, either from the work that you did to get your joint letters out or from things that you've been hearing since you issued it? So what are
who would you like to go?
David, that would be great if you can go ahead.
All right, I'll just, again, jump in very, very quickly. I think one of the advantages that we had is the fact that we were, in Pennsylvania, the way we're organized, between the Department of Education and the LEAs, our local education agencies or school districts, we have intermediate units. And so, again, when we send any pen link out, obviously it goes to our intermediate units. And I think in this particular case, it was very helpful because intermediate units were actually calling here with questions. So I can put them in touch with the folks in school services to be able to answer those questions to help them respond to the field. So probably it diffused some of that a little bit in terms of us not hearing a lot, because our intermediate units were able to move forward with that. I would say that in putting the letter together, as I think I've already mentioned, it was really the work of the deputies. And I think when you look at the letter and the way it's laid out, simple and right to the point, we certainly did talk about how to obtain education records, because that seemed to be the biggest stumbling block prior to this. But I think it's educating the stakeholders within each of those agencies. And again, I think the ability of us to indirectly use intermediate units to do that was very helpful, because interestingly enough, in this work plan that we have developed on a broader scale with child welfare, the courts, and the PDE, I mean, one of the things we continue to talk about is to develop opportunities for training on child welfare and education issues. So as this was being done, we said, well, this may actually help a couple of things in putting this together, because we know some of the major issues we have with kids in foster care or awaiting foster care placement. We have that whole dropout, prevention piece that we need to work with. We have the truancy piece, which then ties into the truancy in cyber charter schools and the way the laws are written in Pennsylvania and who's responsible for going after truant students. So actually, in putting the letter together, it created a much broader conversation here in the Commonwealth. And it certainly helped us, because the First Lady of Pennsylvania is working on this Opening Doors dropout prevention program aimed at middle school students. And we had actually a few of our folks went to the table and discussed that and how important that is for kids in foster care. And we actually had that discussion with DPW and showed the work that we're doing with the Opening Doors piece from the Department of Education. So I think, taken together, the letter actually was like the genesis, I suppose, to help us address other issues which we knew we had. But again, it gave us the opportunity to collaborate a little more closely.
Great. Thanks so much, David. Let me turn this one also to Mickey and Gria. How is implementation going? What suggestions do you have for others in the field?
Okay, thank you. This is Gria. I wanted to address the letter, the joint letter first, and say that it was a very good experience, but it came with its ups and downs, but I think it all ended up to be very productive. But the letter between both of our agencies had to address a number of things. One, it had to address both audiences. Our school district liaisons were the contact from DOE, and of course it had to address the DCF agents and their relative partners. Okay, and in doing that, certain language needed to be appropriate for both of those groups. So that was one piece that we worked through. When Mary Cagle talked about going round and round and vetting the letter from different audiences, that's what she was speaking of. And that took a little doing, but it ended up being very productive. The second thing is it had to be consistent with the relative organizational structure of both of these entities. That is, the Florida Department of Education and its 67 individual school districts, and DCF and its respective regions and CBCs. And so when you're writing a joint letter on policy and proposed implementation for an audience as broad as that, then there's a lot inherent in how that message needs to be said and explained. And so that was part of our challenge. And I think if we went round and round at any point, it's probably because we were trying to reconcile all of those related issues. Okay, in terms of implementation and lessons learned, I think one of the first things that comes to mind is communication. That the first communication we found with the joint letter was just the beginning. It was the very beginning, and of many more opportunities to send a joint message with all aspects of Uninterrupted Scholars, including opportunities for training. And so as we continue to collaborate on the state end and to pass that information, communication, technical assistance onto districts and to regions, then we try to do that as many times as we can jointly so that we're saying the same thing. Where there is hesitation, I think, once the child is dependent by the Department of Children and Families, then we have to remind ourselves, our liaisons, and the liaisons know this role, that it's not about the record, it's not about us, it's about the student. And so once certain things have been clarified and districts are supported and how to implement, best practices to implement, and how to do it within both systems, then the issue remains that this entire effort is about the student. And so these are lessons learned, and I think that for the most part we can continue to reflect on them and then add to our, because I'm sure we're not finished in that regard.
Great, thank you. I'd like to just open it up to the panelists to see if you have any final words that I didn't ask you about that you wanted to quickly share, and then we'll go on to sharing some of the tools that we have at the Legal Center developed for folks working in their own jurisdictions. So any final words of wisdom from any of the panelists?
I guess this is Mary. I just want to say that the importance of communication and the relationship is huge, because when you can go out and jointly train, and send a joint message and be on the same page with your partner agency, I mean, there's no substitution for that. And, it's hard to get there, but when you get there, I mean, it changes how the communication goes out to the field.
Great. Thanks so much, Mary. Any others? All right. Well, we may have time for a few questions at the end, but what I'd like to do now is continue on. And for folks who said that they couldn't see the screen, we are entering the portion of the webinar where you will want to see an image of the screen, so please do chat in if you're having problems. What we want to turn to now is take a few minutes to look at the resources, and this list of questions is some of the key issues that we've identified and that we found in the state guidance from Pennsylvania, from Florida, and also from Michigan are the questions being answered in their joint letters. So which children does the Uninterrupted Scholars Act exception apply to? Who can obtain education records? What documentation is required to obtain those records? How are child welfare and education agencies going to collaborate on a local level? And of course, that's the local school districts, and in some states also the county children and youth agencies. Can data be shared electronically? We heard a little bit about that from Florida already. And what are the parameters governing disclosure? So let me turn now to take you to the Legal Center website, which you should now see on your screen. As you'll see, this is the home page. When you go to the bottom of the home page, you can see, sorry, this is not the home page. I already clicked on areas of focus, data and information sharing. You'll see videos and trainings, this box, purple box here. The Uninterrupted Scholars Act first webinar is up here. The second one will be posted after today, so you can go back to find the resources from these presentations. What I want to do now is take you through a sample joint letter implementing the Uninterrupted Scholars Act. You can find it by clicking here on the screen, and then you'll be able to open it in a Word document and fill it in yourself. Again, I want to thank the smart people in Michigan, Florida, and Pennsylvania who put together this information and really just tried to take the strongest pieces from each of them. It sounds like there's a little bit of background noise on the phone, so it may be that someone needs to put their phone on mute. So as you'll see, this document has gray highlighting where you need to fill in whatever will be appropriate for your jurisdiction.
If there was money for it, then fine. So I guess I'm checking with you on how do I know that?
Folks on the phone, it sounds like we are definitely getting someone's individual conversation that is unrelated to the webinar, so please check your mute buttons and make sure those are working. So at the top, you can identify that the letter is from your Child Welfare and Education Department. The first couple of paragraphs really identify, hold on a second, folks, we're going to try to deal with the sound issue on the phone. Okay, That sounds a little better. So the first couple of paragraphs just sort of recap what the law says itself. But down lower is where you can get into the nitty-gritty of issuing your own guidance. So in this case, we put it as the position of both departments that the Act applies to, and then we left a gray area in order for you to delineate which students fall under the exception. And I think consistently what we found is that it includes, at a minimum, all children placed by the Child Welfare Department in care outside the child's own home. So the state may come up with a more expansive definition, but at a minimum it will include those children. The next section of the letter says it's the position of both departments that the individuals who can obtain records under the exception include the following. And here again we pulled from Pennsylvania and from Florida and others who have started to think out who are those individuals who can obtain the records. But within your jurisdiction, you'll need to identify what that list would look like. So the types of folks who may fall under this in this category are the child's caseworker from the Child Welfare Agency or from a private provider agency working with the Child Welfare Agency, supervisors or managers of agencies or providers, education liaisons or specialists, if you have those in your county children and youth agency or in your state child welfare agency, and other administrators with access to the case plan. This list is not exhaustive. We just included here some of the most obvious individuals who would fall on this list. So we encourage you to really think carefully and have a number of conversations with folks working on the ground with youth and higher up to figure out who needs to be captured in that set of individuals. And then the next question that jurisdictions need to answer is, what is the proof that will show that the individual is legally responsible? So proof might include, as Pennsylvania said, a written notification on agency letterhead that the agency has legal custody or is legally responsible for care and protection of the child, showing that to the school, authorizes the school to release education records. It could be an email from a child welfare agency indicating that the agency has legal custody. It could be a release form, and in just a minute we'll turn to an example of a release form. And again, this is not an exhaustive list, but just some of the ones that we were able to pull from examples and think through on the front end. So take time to think through. There may be other forms of notification that you would want to accept. With a strong language in the Michigan guidance said that when the Child Welfare Agency requests records, no parent signature or court order is needed to process the request. It's a nice way of just recapping the strength of the law. But as David mentioned earlier, Pennsylvania really thought through the implications for families and parents in that this is an exception to the consent requirement. So that means the Child Welfare Agency can access education records. But the bottom line is still it's always best practice to support the parent in their efforts to take care of their child. And they don't inherently, by anything under FERPA or the Uninterrupted Scholars Act, lose all of their other rights under FERPA. And so recapping that information, I think, is a really helpful component to include in state guidance. The next thing we did is look at, because of the variation in systems across school districts, agency and community partners are encouraged to develop or revise local data sharing agreements. So data sharing agreements may be between child welfare agencies and education, might also include others, juvenile justice, the courts. There's an opportunity to think about who's included in data sharing agreements and how to revise those agreements to comport with the new law. The next thing we suggest considering is how you're going to implement Uninterrupted Scholars Act with an eye to electronic information sharing. Again, Florida has really great examples of this in their guidance. We put here, to facilitate information sharing, it may be shared electronically with appropriate protections in place for student privacy, and we just left a blank because I think the details of how this play out are going to be very specific to your state's information sharing system. the next paragraph just underscores that how useful that electronic data sharing can be and what some of the key purposes of electronic data sharing are. And then the final piece that we encourage folks to consider in their letters is how soon do records need to be shared. Obviously, we didn't give a date. That's something for each jurisdiction to come up with on their own. But again, to put a concrete date within your guidance will help to facilitate the speedy sharing of records to help kids get the care that they need. So that's one of the resources on the Legal Center website. I want to take you to a couple of other ones. This next one is a sample release of records form. This is the Michigan form. And what you can see here is what they've done is in that set of bullet points where we said, what do you need to show to a school district to get the records, they've put together a form which I think is very thoughtful in that it clarifies who the assigned foster care worker is, has some key contact information, and then does a great job of outlining what the different kinds of information are that, that might be requested. And I think it's a great reminder both on the school side and the child welfare side of all the possible types of information that could be requested. And at the bottom of the document, what you can see is they're confirming within the document that this person is legally responsible for the child and therefore authorized to receive the information without parental consent. They also did a thoughtful thing, which is make a copy to the McKinney-Vento liaison at the enrolling school so that any services that the child might be receiving through the McKinney-Vento law would also be triggered here. Before closing, so those are the two documents that I wanted to take you through in detail. I also just wanted to highlight how you can find some of the other information. If you look at the top of the Legal Center website, you can click on Database, and you can search by topic for information on data and information sharing. If you do that search, just as an example, you find a number of things here. As I mentioned earlier, that there's federal guidance. That's the third document down. Is the copy of the federal guidance. The fifth document down is the federal joint letter on Uninterrupted Scholars Act. If you also, and other ways that you can limit your search are by state. So if you wanted to find, for example, the Florida joint letter that they issued, just enter Florida in the state portion of the website there, and you can see their letter regarding release of information under FERPA. Similarly, you could enter Pennsylvania here, Michigan here, and you'll be able to find all the documents that we've referred to on this webinar. Going back to the first page, when you go down to data and information sharing, this is where we'll also continue to release any publications on these issues, so you can find them here. So with that, I will close up by just returning to the PowerPoint. Excuse me for a moment. Or my screen has gone blank. There we go. I just want to highlight that we raised a couple of things on this call. We talked about the release forms like the Michigan one. We talked about joint agency letters in great detail like Pennsylvania and Florida have issued. There are obviously many more types of ideas for state implementation. States may want to work on interagency agreements or protocols about their information sharing that go into more detail. States might think about model court orders relating to the release of information sharing about kids in the child welfare system and court rules that also relate to this. So we've sort of done the tip of the iceberg, what we think are the most useful things as you start your work on data and information sharing under the Uninterrupted Scholars Act. There's much, much more that states are doing and can do. We just want to hold ourselves out as a resource. Please use our website, join our listserv, as you already have, join the conference calls, but also reach out to us if you see things that aren't on our website, or if you have specific need for technical assistance in your jurisdiction. We are here to be a resource for you. So with that, I will once again thank so much our panelists for joining us. Mary Cagle, David Volkman, Mickey Presley, and Greer Davison, thank you so much for the time you put into this and for letting us hear about what's happening in your state. And thanks everyone for joining and taking the time out of your day to join us. Exciting times in information sharing and between child welfare and education, and we look forward to hearing about all the developments in your states. Thanks everyone.